What would we need to know if we needed to determine what entity, whether it be an existing or new entity, should have the authority to investigate commercial spaceflight accidents, including those involving human spaceflight participants? How should investigations be handled? What type of expertise would be needed? And are there other high-risk industries that can serve as models?
I really have not given that any thought in in preparation for the testimony today. But when I testified in 2011, I believe I did address a couple of issues related to that. And I think the National Transportation Safety Board generally has authority to investigate accidents related to transportation. Unless the law has been changed, space was left out of the actual list of those modes to which they would investigate. But I believe there's an MOU between the Commercial Space Office and the National Transportation Safety Board for accidents above a certain limit amount, or those involving human beings, would be under their jurisdiction. And if we go back to the shuttle Columbia accident, I believe they were also involved because they've had a lot of expertise in this area. NASA, of course, in the human space flight has had experience as well in accident investigation. But when something like this happens, the expertise within the government is found among the various agencies, and I don't think any agency would decline to participate.
Thank you. And I'm going to ask Dr. Nield, what data should industry be required to collect in order to facilitate a potential accident investigation should an accident occur?
We currently require a lot of information as part of a launch license process in terms of the vehicle and toxic propellants and the trajectories, what the hazards are, and so forth. So we already have that in place. And as Dr. Hertzfeld mentioned, we currently have MOUs, Memorandums of Understanding, between the FAA, the National Transportation Safety Board, and the Department of the Air Force to conduct investigations should there be an accident that occurs in the future.
Can you think of any data that isn't being collected that might facilitate an accident investigation, or it's your position that everything that should be collected is already being collected?
I think we have a good set of requirements in terms of what information we need up front. To build on your question, though, I think what could really help the industry going forward is a greater willingness to share information about close calls and incidents and accidents that do occur among the various companies. And of course, that could be a difficult issue when you talk about proprietary data and competition, but that could really help the safety.
Terrific. Thank you. And for all the members of the panel, the Commercial Space Launch Act requires that space operators, before receiving compensation or agreeing to fly a space flight participant, inform each participant in writing about the risks of the launch and reentry, and it's my understanding that that's according to the vehicle type. Now, some say that informed consent is not a waiver of liability for any enhanced exposure to injury caused by the operator's carelessness, if any, and they advocate having each spaceflight participant exchange a liability waiver with the commercial launch provider. So basically, parties would agree not to file claims against the other party if there's an accident. Now, others are concerned about the rights of the passengers and their families, and that they should be protected in the event of an accident. So what are your views on whether there should be cross waivers between spaceflight participants and commercial launch providers? Is informed consent still appropriate as we move to regularly scheduled and paid suborbital flights? And I think I'll start with Dr. Hertzfeld. I don't know if the other of you are lawyers. It's a bit of a legal question.
The way the system works today is the wording of the informed consent statement is left to the companies, I believe. Many states that have spaceports or are considering spaceports have passed legislation with wording on the informed consent, and each one is slightly different. And I think that is something of concern. Looking ahead, states, it's quite fine for states to compete against each other for economic reasons, but some of these some of these laws are aimed at protecting the operator from a suit by one of the passengers if something went wrong, and with the exception, I believe, of willful actions or gross negligence. They read differently, and this may be something that the Federal Government should consider for preemption, and it might be because the FAA has more data, more information on all of the companies and all of the risks, wording that perhaps should be drafted by the FAA and be uniform throughout the country.
Thank you very much, and I see my time has expired. I yield back. Thank you, Mr. Chairman. For all of the distinguished panel, think back to the airline industry. The FAA previously had dual roles as both advocate and regulator of the airline industry, and that was eventually split, and the FAA only retained the regulatory role. But in contrast, now the FAA has both roles regarding commercial space. So the Office of Space Commercialization and the Department of Commerce seems to complicate the issue, as that office also has responsibilities that include industry advocacy. So what are the pros and cons of removing the advocacy role out of the FAA, and if that decision is made, what entity or entities would be or could be given that responsibility effectively? Dr. Nield, I'll start with you.
Thank you. I would point out that from the first passage of the Commercial Space Launch Act 30 years ago, there's been this dual role. On the one hand, promote safety, and on the other, encourage, facilitate, and promote the industry. And that sounds to a lot of people like it could be a conflict, and that question has come up over the years. Congress has asked for reports. We've done independent studies. We've had debates about that. But as I look back, I think it has worked very well. To me, the encourage, facilitate, and promote role is a way of thinking. It's not a compromise of safety in any way. And if you look at the record, there have been 254 licensed or permitted launches in those last 30 years, and none of them have ever had a fatality, serious injuries, or significant property damage. So I think we have the balance about right.
Dr. Cackley or Dr. Hertzfeld, do you have the same opinion?
Well, we haven't looked at the duplication across FAA and the Department of Commerce in particular, so I don't have an opinion specifically on them, but I do know that GAO has looked at duplication across the Federal Government in a lot of different areas, and it is something that we identify as a concern, and it's something that should always be reviewed and considered as to whether there is something that could be done differently.
Thank you. Dr. Hertzfeld?
Yeah, I just, certainly industry has not complained at this point, and I agree it has worked fine up to now. I think there are a couple of issues that require monitoring in this area. When the agency was established in the commercial space launch regulation, we had one type of launch vehicle, ELVs. And then there was, at a point which could come back at some day in the future, reusable and launch and reentry vehicles that can come, land, and take off again. We don't have that now. But if we begin to have a series of different technologies, a series of different types of vehicles, all regulated by one agency, then there could be an issue of some regulations favoring one type over another, all of them well-meaning, but not coordinated in a way that, and it could affect companies in terms of promoting space.
Thank you. And I'm going to try to get one more quick question in, Dr. Hertzfeld. With the likelihood of more frequent commercial launches, I wanted to ask about your position on whether developing incentives for private industry to develop insurance pools rather than as an alternative to government indemnification. So in your view, are there some examples of incentives that could have the potential for encouraging those insurance pools? Are they a possible alternative to indemnification, especially in light of the need for newer launch vehicles to pay higher premiums until they establish reliability?
I think the major test would be the growth of the industry. If there are enough launches, then there's possibly enough business to warrant that. This same, in a slightly different way, but the same scheme of indemnification was applied with the civil nuclear area, and eventually they were able, when they built enough nuclear power plants, to have their own pool and cover their own insurance. I think it's a ways off, but it's possible.
Thank you very much, and I yield back. Thank you, Mr. Chairman.